Memo bibia kwaba eba Melodies TV so. Alban Bagbin lawyers enkrata wo motroye edekoma Supreme Court. Supreme Court say mo order modema Alban Bagbin no enjina so bia eni so. Na ko hin no. Court document no ebia ba be kamensa. Now I want to go through the court document so we understand the factor Alban Bagbin a lawyer said they are tuja. Let's try as much as possible to understand what they are saying. Here, who the sense more or can a politics keke no more and I say omudika say was say womoka and some more womoka. And then your first time subscribing, now click the notification bell on the so am I now quickly and consume. Let's start from this is the part of the document Mensa Akaim say initially, it's with one court for language and all that. Now say a reading of the plaintiff's rights and accompanying processes, a copy of which is exhibited here to and marked C, by which he purportedly invokes the jurisdiction of the courts, will reveal that it was filed together with a statement of claim, which is not required by the rules of the court to invoke the court's original jurisdiction, but also without an affidavit in verification of the facts relied on in the statement of case to prosecute the suit, which is mandatorily required to properly invoke the court's original jurisdiction. The first point I read, na say Alban Bagbin lawyers cry say the processor ye invoke Supreme Court no kra no wrong. Na say afenyoma ken ene ne lawyers nyama nka wo se wo mo ye na nka wo mo etwe Supreme Court aso eba asem ne so no kra no. Omo anye sa ade no nti eba ne sen na Supreme Court ya anye sa ade na mudi egina so de ama ruling. Now, for people who don't understand, every lawyer knows this. Say, eya na yen crofo say, oh sorry, ya now the wasem akwa kopi wo court dabi. How you file the process, and the processes are, o filing what you say, how you file the process, no, it is equally important as the case. Into a lot of the time, no, eya na, especially, uyobia what I share some brofo no crime stories now. Utumi hu ne say, even the way police for investigators at the investigation crana so one no in a legal way crana you to me bo asem ni go enye se bia nipa ko no bone na ya ka no ndi o ebia wo bia kwa kokun obi ya che nipa ko se wa kwa kokun obi but arrest warrant ye de ko search nipa kro no ye de nya evidence say indeed onu no ku nipa kro no crana so mo ankwa ankonya ne yie a nipa ko ne lawyer to me gina so ema ye bo asem ni gu enti lawyer bia nim say the processes are would they file court case no it is equally important as the court case one file with a proper processor any say was here so also the first point Alban Bagbin right honorable speaker Alban Bagbin and lawyers catch judges no cra say a kwan afenyo marking the free court no cra eba so no cra no wrong I say such non-compliance with the rules of practice and procedure for originating processes by which the court's jurisdiction is to be invoked renders the proceedings incurably null and void, just as I'm saying. So, what court now can use processor, any right processor, or case no a null and void. The case a case null and void, and not just a seminal crano, ya buegu. Intino, Alban Bagbin lawyers, age in aso. So, processor or mode by no. In Chayi, in Nicolas and court in the ruling. I say a reading of the purported originating processes by which the court's jurisdiction is supposedly invoked, Exhibit C, will reveal that the pith and substance of the plaintiff's case simply requires a resolution of the question whether or not, on the fact of the case, the provisions of Article 97(1) and H apply to the members of Parliament named in the purported processes. The words used in Article 97(1)(g) and H of the Constitution are clear, unambiguous, and have no disputed meaning, and no basis exists in the processes filed for assuming that there is a dispute as to their meaning. In just someone walk and say, "Oh, share." Afenyoma kin case kra wo de ba court ne kra na. Asem ena Constitution no eka. Say asumesi Constitution aka say obenten asumesi ekokodwani party we ya e wo say yeyi ne to akonwa na okọ say wodwani party for aside party a wo de ba e wo say yeyi akonwa ne free eho say afenwoma in the case no aba court a ejina court ne so say was so say oh sa article say ni say no afenwoma ke ne bia wasem ye de ana say we asem na nye sa neti ana say eye interpretation ene ye de ba wo hwe sa article na eye unambiguous enye say bia e wo different meaning eye clear language Ghana fo wo bia ate ase enti nanka e was Supreme Court no etre say ebia say na Supreme Court yen yeti ade na say eye interpretation e nanka was Supreme Court ema but say wo ma orders at the end of the day ne kra na sisi aye nim say indeed when na asem ye de no because at the end of the day we hear Supreme Court ne kan no ma ruling bia o say the words used in the provisions of Article 97 1G and H simply mean what they say. That is to say, where a member of parliament leaves the party on the ticket of which they are elected to parliament to join another political party or to become an independent member of parliament, or where a member of parliament elected as an independent member of parliament joins a political party, they shall vacate their seat. To attract, say, article no, simple, in simple English, waka. Say ni pa krono party a wode buy no free sa party ni mu a ni seat no be vacate clean English and there are then na say asem no ye pese ye dane no adi waka ya kan o constitution. What are we saying? I say under and by virtue of the provisions of Article 99(1) of the 1992 Constitution as interpreted in binding decisions of the court, it is only the High Court that is clothed with jurisdiction to determine the issue of whether the seats of the 4 MPs shall be vacated, applying the constitutional provisions of Article 97 1G and H to the fact. Tomo sonso eka se Ghana embremu Article 99(1) say eba no parliament na e wase yeyi ekonwa free MPB enho a eye only High Court ene wo kasa ewo ho. In the first place ne kra no Supreme Court decision a wo mo makra no enye omo ena mra ne chese wo mo na omo ndi asem ne so eye High Court. Also, there can be no doubt about the fact that to apply the provisions of Article 97 1G and H to any set of facts, the High Court to which jurisdiction is conferred by the Constitution must express its understanding of the provisions of Article 97 1G and H under consideration. Nti was so call High Court na High Court no kokot tre ono ne ntiase of Article 97 1 and thereby bedane asemi in expressing its understanding of relevant constitutional provisions on whether the seat of a member of parliament is vacant in order to apply the constitutional provisions to any set of facts in the exercise of its jurisdiction under Article 99(1) of the Constitution. The High Court cannot be said to be exercising the Supreme Court's original jurisdiction to interpret the Constitution. It is required under the said Article 99(1) that where the question whether a seat in Parliament is vacant arises, the suit is initiated in the High Court, and if the High Court considers that a matter of interpretation arises, it is obliged to stay proceedings and refer the matter to the Supreme Court under Article 132 of the Constitution. Indeed, this has been an argument in Kofu Bebrena Erezi. Say the Constitution is clear. Say asem way ba Fako High Court. Now say Koko Piem wo High Court na eba ne say e was say interpretation and no kranya order interpretation. Na interpretation it say entretremu. Ya ka say wo ma order na say wo train nipa kro ne say wo ma no order say wo hye ne so say ye say be ka interpretation na say wo train na ade say o we no say na tie say na ntiase ne tie ben no na nya order. Inti Ghana mra tre say case bi say ba yemfa nko High Court na ye di kopiem wo High Court na no no entretremu bi ba na di akọ Supreme Court na Supreme Court e di entretremu ayeden aba. Inti Alban Bagbin the lawyers no stated that fact. As a binding precedents of the court have also affirmed the principle that whereas in this case a matter is properly within the jurisdiction of another forum, the court must not assume jurisdiction under the guise of constitutional interpretation to entertain the matter, but must decline jurisdiction. So someone what can I say constitution aka say e assume si no di asemo in the name of interpretation inti eni kwa say yedi mirika echo Supreme Court because Supreme Court no need jurisdiction over this case. Only jurisdiction. Or say binding precedents na no netre say de atwem de asi atwem kra eda ho a eya senso de a eda ho. And I'm giving you a perfect example, a Sao case. When the Sao case started, omo yes omo dey go Supreme Court na bomu gu yes dabi eba no about vacancy ni sa seat ni sa MP nsensem na eye High Court e ma send call back to High Court nti na dey ba ne sen e na Supreme Court o pesa otina case we so the dey sa eye High Court na so otina case ne so I say before making the order exhibited hereto and mark A, the court observed in Exhibit B that the first defendant had objected to the purported service on him of the current action. First defendant cannot find the basis on which the court concluded that there was proper service of process on him. To here, in the first place, Krano, Udi obi court was serving nipa krono. Naturally say, court no Krano mo to me ampe evidence say indeed Alban Bagbin was properly served on the case. Mo atena so amosi mo edi case no. I said the first defendant takes issues with the court's endorsement of the supposed service of the said processes on the first defendant as proper service of a process from the Supreme Court on him because the said service was made in blatant breach of statutory and constitutional prescribed and agreed between Parliament and Judicial Service manner for serving processes emanating from registry of the courts on members and officers including the first defendants. Nto tremu a senia ye ka no senia ye ba be serve Alban Bagbin ne kra no Parliament any judiciary no enya understanding say o pesa o serve Parliament there's a proper way e was o serve senia ye serve Alban Bagbin no that was not the proper way of service. The Supreme Court any evidence say Alban Bagbin indeed was properly served. So why did the Supreme Court go further to make the pronouncement they made? Because I've told you that serving someone is equally important as the case amudi no. 170 year case na enkoso. Enti wo Supreme Court no only evidence say Alban Bagbin no he was properly served. Enti why do you sit on the case and bring a pronouncement? It's over here and also your other angle Alban Bagbin lawyers edeba. I say at all times material to the present application, Her Ladyship, the Chief Justice of the Republic of Ghana, who presided over the court, always knew that the supposed service on the first defendant of the processes of the court was made in breach of the provisions of Article 117 and 118 of the 1992 Constitution, as well as the agreed protocols for serving the first defendant with processes from the Supreme Court. Into a more say, Chief Justice not in a case, or no claim say Alban Bagbin no yan man correct service. Yan 7 year case where air course no Alban Bagbin yan 7 year. Chief Justice nim or not say a case so onim sa same way. Chief Justice onim sa same way. Ti ended the ban saying. Or say exhibited here too and marked Exhibit D is a copy of a judicial circular dated 12 July 2024 in respect of service of processes on members and officers of Parliament including the first defendants. So mu ye no omo judicial service na nkasa no issues are we release here on say o person will serve you be a 7 years and ye case ne kra no and there Alban Bagbin lawyers use sa statement no as evidence e say one na kan wasem say wo ko serve member of Parliament say na was ye serve no e was ye serve ni yi and samunya mo be kai eno na ma Okujato Ablakwa o winning contempt case against Reverend Kusi Boateng no because Reverend Kusi Boateng say yenchi Okujato Ablakwa ntum because yakwa serve no obutu court document no which showed gross disrespect towards court but no Okujato Ablakwa lawyers enso sa Chief Justice we ne circular bia wo de ba abonten omo use no as evidence a wo de court judge ne say Chief Justice Nansemu Awakande say, "O person will serve a member of Parliament. This is the proper way." Inti say 170 million na me butu papers na. Didn't turn up oche me. Inti judge ni tina case nso ka say indeed Okujato asem ye de. Inti ende sa asem na Chief Justice ni Troy no. Eno na Alban Bagbin the lawyers no. Omo de eno nso ye evidence a omo de tre say one na wo kan asem wi na say yan man be serve yen ye a. Die ntia e na afi wo say wo tina case nso e de pronouncement e den eba. Nti no eno eye exhibit D our modiaba. Now I say by virtue of exhibit D, Her Ladyship the Chief Justice confirmed to all registrars of the court and bailiffs the procedure agreed between Parliament and the Judicial Service for 7 processes emanating from the courts, including the Supreme Court, on members and other officers of Parliament, as well as the first defendant as constitutionally prescribed. I say Exhibit D, as stated in it, was issued after the first defendant drew the attention of Her Ladyship, the Chief Justice, to potential breaches of Articles 117 and 118 of the Constitution by actions of some officers or some persons acting on behalf of the Judicial Service, which confirms that Her Ladyship, the Chief Justice, is fully conscious of the importance of collaboration between equal arms of governments to uphold the Constitution. As apart from the first defendant's objection to the service, which the court noted but disregarded, the evidence made available to the court by the plaintiff showed that the supposed service of the processes in this suit on the first defendant was made in clear contravention of the express directions contained in Exhibit D, and accordingly the provisions of Articles 117 and 118 of the 1992 Constitution. To Tremwa, send your survey, more judges, Necrano, more admitted, and so you went on to give your pronouncement. But one Casaun Samoa Wakano, it breaches it. I say the reason for my disposition in paragraph 25 herein is that it is clearly stated in Exhibit D that the first defendant is only properly served with processes from the court on Mondays, and the affidavit of service exhibited to the plaintiff's ex parte application before the courts confirmed that the first defendant was purposely served on Wednesday. Now it goes further to say, in terms of order staying of execution of rulings, the Supreme Court's powers under the 1992 Constitution of the Republic of Ghana and statutes to stay execution of rulings are limited to rulings of itself and courts lower in the judicial hierarchy, but do not extend to a ruling of the Speaker of Parliament who is not part of the judicial hierarchy. Into 3 issues in Alban Bagbin, the lawyers raised. The first issue is the jurisdiction. The fact that in the first place, Supreme Court na yedi case we but na Supreme Court na was setting so, and the Constitution is clear on that. It is Supreme Court yedi case na ba mo so case na so clearly ruling na ba no kra na etia Ghana mra. That's the first issue Alban Bagbin lawyers raised. And the second one is with the service. Say one kasa okra what say only Parliament acquire agreement say the court process say be serve mo, there is a process. Omo follow that process no. Now so eba na still mudi case no. Inti no 2, the second case. Now the third one, and also somewhat no, it is about jurisdiction, but not like the first one in the sense say Supreme Court stay of execution the only people that will be to media momo the courts are Supreme Court na say. That is the High Court, Appeals Court, and all the other courts are omunina Supreme Court say. Parliament enya courts. Parliament enya Supreme Court say. Into who to me in tray and say who the stay of execution to Parliament process eso. And this is the third case Alban Bagbin the lawyers raised against the Supreme Court. What you say? Also, with regards to the first defendant's ruling in Parliament, a separate arm of government into emboldened or say a separate arm of government who need to me that is the meaning. With regards to first defendant's ruling in Parliament, a separate arm of government, therefore, such rulings are not rulings within the judicial hierarchy, so as to be the subject matter of an application for stay of execution and a judicial order staying the execution. Yen shall say, to me, man, my order to say the yesha was say yen stay execution. Sabe sabe in prayer, son. Oh, ma, e wo fie. Oba, they are open so school, no be to me the ashana say, and the menko. Na me papa wo fie, and I'm young as wo papa, and I'm young as ye papa e wo mi fie. Na wo no, wo free wo fie no, aba be ka me say me no, mame ba nko school. Da bi wo de wo na obetumi a kire wo ba se ma wo ba nko school. Ene de ye wo ba nti wo na wo hwe ne so. Me so me wo ba me hwe me ba so. Na wo papa no wo ba be ka kire me say me mame ba enye den enko school. Me nya de me ye ne say de nta na me mame ba ko school. Da bi untumi ntre me sa, uni tumi a betre me sa. And basically no NDC for third case no. This is the understanding. So won't you ask ya. I say also, and specifically in relation to the court's jurisdiction to make orders in relation to matters before it. The court's orders are only properly made and within the court's jurisdiction where the matter before the court can properly be entertained, not merely by a claim that there is a matter of constitutional interpretation. Further, the 1992 Constitution of the Republic of Ghana provides for the well-known separation of powers doctrine, whereby the scope of the powers of each arm of government is set out, and no arm of government is expected to overstep its bounds. So I say Ghana mrane try say obia wotumi, executive wo mutumi, judiciary mu wo mutumi, yen legislature so ye wo yetumi, mrane try say untumi mfiri wo ho. Emfa wo tumi ma metena yen ye de so dabi. And this is clearly put in Alban Bagbin, the document. I say with regards to the breach of the rule of natural justice, when proceedings are instituted against the Speaker of Parliament, notice of the said proceedings ought to be served on the Speaker to enable the Speaker to have the opportunity to be heard. Into more say, in fact, nipa krano odie wempo enyembra yakano natural justice yakase bibi a natural justice adia ewo ho naturally. So obi ni obi nya asemo a eni kwan se utie nipa ba ko de natural utie ba ko de na wakwa akotie other person nso de yede asem ne bra wu Supreme Court no na ke wose utie Alban Bagbin nso ne side wentie omo side na wo the ruling aba in favor of one person. Into na no so the fourth issue Alban Bagbin and then the lawyers raise against the Supreme Court and the Chief Justice. I say while in regard to applications to say execution of decisions of court within the judicial hierarchy pending appeal, the court may entertain and grant ex parte applications. There is a presumption that a decision of a lower court in the hierarchy sought to be stayed is valid until set aside, and grant of a stay requires proof of exceptional circumstances. In the circumstances under which the court made the order, there was no reason to deny the first defendant a hearing, especially as to the knowledge of the plaintiff. The next sitting of Parliament at the time of the ex parte proceedings, which the court also had judicial notice of, was on Tuesday, 22nd October 2024, and court could have given the first defendant a hearing at the very least on Monday, the 21st of October 2024. Now, the issue they say yaka say ex parte they say ebia mini wenya asem na asem na mini wenya no bibi koso say manye ntema nko court ankwa nkoje ex parte ebia bone na udi no bekoso edi. Nti that is why our lawyers court koje ex parte. Nti no ex parte no eni kwan say yetie other person in the side, because say ye ka say ye twani aba betie ne side ye beti ye ne bia bone no wedi awie party ase nti no mu no ye de ex parte. Nti ex parte na enye de bia na udi mirika beje ex parte for very circumstances bia ye hu ne say ye da very serious circumstances that time no ye je ex parte. Nti o say wo hwe case we afenwoma akemo ba say wo mo ba beje ex parte no na enye serious we be abeka say bia na parliament e call recess into no say decision we say yanye ne ntem ne yen take decision against it. A parliament begu ana bibi dabi. Parliament was going to sit the next time. Na in someone e kwaso wo parliament no in parliament e betena say say parliament e call recess ana bibi. Parliament was going to sit. And a parliament betena say throughout that week. It's any say ye di boni bi aboni na ye di no ased ye say yan hwene yan so anu ende a ebebo man no dabi. There was always a chance. It's in the first place no kran na ni kwan kra say o grant sa ex parte no e ka o say o tro ana wo ma o tie yen so ye side, because ex parte ne de mama ati ase de entia ye ma ex parte no we no na enfole under eno. So basically that's the point. Significantly, the plaintiff had filed a motion on notice for an interlocutory injunction along with the writs in this case, but abandoned this process in favor of the flawed application ex parte for a stay of execution. Exhibited here with marked E is the said motion paper filed by the plaintiff. The unexplained shift from a motion on notice to a motion ex parte is what the plaintiff used to prevent the court from hearing both sides. To say afenwoma kenekran in the first place or file for injunction Into injunction no and no say indeed there was no need for ex parte because injunction say and no okay yeah they too so brana so be kan de near say ye be ma why den what was one but ex parte no ye other side ne de into afenyo mark ne kran initially no a injunction of file for na say no no kran him say ade we kran ensem fata say ye be ye no ex parte tie ba ne say na afei oba be ye no ex parte amo apene. This doesn't fall under ex parte. I repeat paragraph 35 of my affidavit and depose further that in not drawing the court's attention to the pending application for injunction at the time of the hearing of the ex parte application, the plaintiff offended a cardinal rule in ex parte applications, which is that the applicant must act in good faith and must draw the court's attention to every relevant fact. Tiase woko quarter. I was acting in good faith. Oko quarter, I was say uma court no aso eba every single issue a woni mu asem so. Into the fact that afenyo can buy one ma court 90 years say initially no or file injunction and say na wo be file ex parte no, he didn't act in good faith. Democrat say he is hiding something. Aye boni a wedi. Court nso de wo ba na wo di boni na wo hide bibia ye bo wasem gu. Into basically no Alban Bagbin any the lawyers letters our more tro ediako any or see in terms of the court's power on ex parte application for interlocutory injunction, for instance, it is only permissible to grant such an application for up to 10 days but not pending the determination of the suit. The court's order is unwarranted by any rule of law or procedure or practice. Inti utie asemwa Alban Bagbin a serious issues are the lawyers raise you asemwa mo sanso kan say wo de enye hwe ex parte ne mo se mo beye eni kwan kra say first no na eni kwan kra say Supreme Court na otena case ne so wa ba betena so eni kwan kra say otumi ma order na o man no nanso wa man eni kwan kra say case we kra ekoda ne ex parte nanso wa ye ne ex parte o de enye hwe say nyama we na eboni na we di kra na o de yembu ye ningu so ex parte kra no ye man for 10 days pe see ye ma ye kone ye kwaji ex parte on a ruling and on a matter on an issue for 10 days pe inti se wo se wo ma stay of execution sa stay of execution no just for 10 days ex parte ne sa nete na mo ma ex parte ne pini wie no mo san so ka say mo yi 10 days limit ne free ho na until say ye be di case ne wie no me decision na me make no mo nti ase ati bi da bi ex parte o call for ex parte na say o call for 10 days and indeed afenyo man kemokra call for ex parte no that is what they cited but Supreme Court ruling no mo interested da bi yen wo 10 days now we request no eso inti ye no indefinite which clearly is out of bad character. Inti also ye issue Alban Bagbin lawyers omwerezi or say further, although the court may make consequential orders after hearing an application, such consequential orders must flow from application but not be distinct additional orders not covered by the scope of the application. Ituti asemwa wakan yes court no ewo mra say ana ewo to me say omo abemo orders on an issue but orders na wo say nipa ko no di case neighbor na e free ne ho yemfa ne say wo bi e di obi akọ court for defamation nipa ko no call for defamation asemo wo kan say nipa ko no wa say mi din na midin na wa say no misusu say wa mama boka 1 million inti muma nipa ko ntua me 1 million inti court no ewo to me say obema orders but orders na court no ebema no e wo say e free me request mu nti bi akwa no betumi aka say 1 million na wo request no isa edo esundodo mema nipa ko netia o e bi 100,000 because me court me ye me hwehwe mu me hu ne sa but court into me nka say 1 million na wo request no isa mema nipa ko netia e bi 100 million da bi court into me masa order no order na court no be ma no e wo say free nipa kro na no di case no aba emu nti afenyo mark in the case aba say ex parte stay of execution for 10 days who as a court no who ni who kwan say okokoka ma say da bi mema case no indefinite mema no more than 10 days da bi who ni who kwan say bibia nipa chronic case or the aba na so di so e dey make ruling nti in the first place ne kra no court no aye mistake wo ho it is also an issue we mo raise I said the application before the court contained a straightforward prayer for an order staying execution of ruling of the Right Honorable Speaker, which the court granted in terms of the motion paper, but then went on to grant additional and unsolicited orders. Into what case I had by no. Yes, stay of execution, one man. Nanso, was also go further, overboard. Adi ayem bisa busybody. The ayem bisa say ye now kwa ye. Obi asuma. I say the court granting the ex parte application Exhibit 1 on the ground that the first defendant breached the right to hearing of the affected members of parliament involved a gross failure to appreciate that. Inti say court no ema order no ex parte na wo man no or say Alban Bagbin a mistake. Say wentie omo a omo ekonya no ye free on wentie omo asem. Court no edi gina asem no so no dey take a decision no. But Alban Bagbin and Crawford say, oh, court no ye mistake. It was answer now kind of so na the entire ye mistake no one any. The right to a fair hearing is only properly asserted by the person whose rights have been so breached, but not a third party like the plaintiff, who in this case is clearly meddlesome interloper. It is a walk as a yentie will be as a was any bakun never be reported, Ganam Rasanete. Timbakwa yet now on no fan who de sono. On no also Baba report say, hey, Alban Bagbin and entie masem and the wama ruling, and the anka beti asye. But a friend you marking now on no buy and on no aquadane busybody, Obian Suman no di mirikaba. But you see, the funny thing here is that the court made a decision claiming that Alban Bagbin didn't hear the speakers. The members of parliament. Intia na Omo court make that decision. But the courts themselves didn't also give Alban Bagbin hearing. Do you see the irony in all these things? Osi Alban Bagbin when tie MPs na sem court your friend saying constitution akade send the no sesan e was o tu ni free so now so na ka was Alban Bagbin o tie MPs no enimu asem ansa. Osi when tie wo mu enimu asem. Now so court na o ka se when tie wo mu enimu asem no. Unso when tie Alban Bagbin enimu asem na so mama ruling. Say when tie wo mu enimu asem nti wa bo no Alban Bagbin na asem egu. Into unso de na yem mongu ana because unso when tie Alban Bagbin enimu asem. Anyway, I say, in any event, as the affected members of parliament were in parliament during the proceedings leading to the first defendant's ruling, but chose not to be heard, such rights are deemed waived, and the law recognizes a person's right to waive such a right. MPs are more parliament. Omo feel say Alban Bagbin se mo a wokan ye no, anto omo asumo a ke wo so omo kasa. Omo ankasa. Wonso ubegina echi. Baba beka say adenti na Alban Bagbin wenti o mo asem. Na bi wo ho na ade ni isi. Na se wo ho na ade ni isi na wan kasa. Na twese wa ma ho kwan sa ade ni isi. Ghana mra no sa na ete. Iti enye obi a wono ye third party na oba be kasa mani pa kono say ya mane kwan say won kasa. No parliament on ade esi ye. Na ko he na sa ade no on pa. Anko be kasa oyekom. Third, the void nature of the order is evident from the fact that the order is also directed at Parliament, which is not a party to the suit, and was also not given a hearing. The Speaker being sued not as a representative of Parliament, but on account only of a specific ruling. Nti sɛ nea meka no, sɛ Speaker no nso no wentie wɔ no nso asɛm a wama ruling no, nso o deɛ why a mistake. Nti ɔno nso asɛm a wɔka no no. Also, the effect of the court's ruling is to interfere with matters before the Parliament of the Republic of Ghana by seeking to regulate how Parliament must conduct its business. So, what I say, courts need this issue we are making. No, or no person or Parliament send your Parliament in your nejuma. There is the urgent need to ensure that the court is not seen as interfering with Parliament's internal business, especially as Parliament has constitutional power to commit for contempt of Parliament, which it may exercise in circumstances such as this. Intino oha omonso country court ne say e was say mo make sure mo hu ne say mo fa mo nseme member parliament so because mo hwe ni ya mo nso ye be chemo for contempt of parliament ade amu ye parliament business na mo betre parliament ye oye no mo judges no ye betumi a chemo for contempt of parliament. That's what it means. I say this is there is the urgent need to ensure that the court is not seen as interfering with Parliament's internal business, especially as Parliament has constitutional power to commit for contempt of Parliament, which may exercise in circumstances such as this. So oka say one here or more parliament we can bet more judges no for contempt. Basically, no. That's what it means. Let me read this line again. The line 42. I say there is the urgent need to ensure that the court is not seen as interfering with Parliament's internal business. I was saying, who say, I was saying you're making sure the court no ma insist I said your modem who be share Parliament jumamu. And I say especially as Parliament has constitutional power to commit for contempt of Parliament. Parliament will to me say you be chinkrofo for contempt, which it may exercise in circumstances such as this. Which it may exercise, not just say Emrana mayen to me say will be adding the home before a parliament as same one yen for contempt. One here as our case where you bet more judges no for contempt. Basically, that's what it means. I say it is important to add that some of what is in the ruling of the court as the basis of its orders could only have resulted from either fraudulent representations by the plaintiff or being purely speculative findings and not based on any evidence placed before the court. For instance, the mudijina so mudi make way no fraud. Ena enye nipa kra wo se wo ba court wo eba be e de asem ne ba na or de asem ne ba e. The entire Kasan say the court's finding that the first defendant's ruling will also likely lead to the alleged weighting of government business in Parliament and plunged the due management of the affairs of the country into possession disruptions. Into the first intro because the Bakona ba Parliament waba court and a waba be control na mudi ruling amano. Intro first I will try and say or say someone man is a ruling ya Ghana basa yobe to me esi. Intro ruling way Emma Basabasa UBNC Ghana. Second, and they say they claim that the Speaker of Parliament was aware that bailiffs of Supreme Court had served the current action on him through the legal office of Parliament. And also intro say momani ebe jina court ebe chantro say was service speaker and a speaker aware no and also intro it's just obi aba be jina court aba be chantro and am also mo jina so mo entie yasem and am ama no favorable ruling. Nti Alban Bagbin lawyers and krata wo mo atroni very powerful. Now maybe what I take from it and they say there were more warning parliaments and obo warning court. Someone here ya on be for contempt no. That is it. Won't share your comment box anymore. But that's it.